Hello guys, and welcome to another episode of my lecture. On today's episode, I'll be talking about the Nigerian experience of Res Gastae Doctrine. Now, we've already spoken about the common law perspective. First, from the strict contemporaneous rule, as stated in the case of R V BEDINGFIELD, to the sufficient contemporaneous rule, as stated in the case of RATTEN V R and also in R and Andrew. Now, what is the Nigerian perspective of this Res Gastae doctrine? This particular Nigerian perspective is divided into three. This video, we are going to answer two salient questions, which I'm going to read to you from my notes very soon. Now, in the next video, I'm going to be talking about the Nigerian perspective, Nigerian cases under the old act, using section 7 of the old act. And then in the last one, we'll be talking about the Nigerian cases using section 4 of the new act. So let's start with the questions. It should be noted that section 7 of the old act is the relevant part dealing with the Res Gastae doctrine, which is now section 4 of our new act. So the two main questions are: number one, are section 4, that's the previous section 7, and Res Gastae the same thing, or is one wider than the other? The second question is, are Nigerian courts justified in admitting fact based on Res Gastae in total disregard of section 4? Now, it's very pertinent for us to know what exactly does the provision of section 4 contain in answering the first question as to whether or not it is wider than that of the common law doctrine of Res Gastae, or the common law doctrine of Res Gastae is wider than section 4. Now, section 4 tells us that facts which, though not in issue, are connected with facts in issue as to form part of the same transaction are relevant whether they occurred at the same time and place or at different times and places. It has been agreed by some authors that this section is wider in scope than the doctrine of Res Gastae, because strict contemporaneity, according to R versus BEDINGFIELD, isn't a sole requirement. Why did they say it is not a sole requirement? Go back to section 4. It says that facts which, though not in issue, are so connected with facts in issue as to form part of the same transaction. Now, strict contemporaneity will tell us that it must happen at the same time and at the same place where that thing is going on. But in our act, it tells us that at the same time and at the same place, or at different times and different places. Do you understand? Now, however, such position is uncertain in view of the decision in RATTEN V R and R V Andrew. It seems to be the same scope with the doctrine in that the section encompasses both the strict contemporary rule in R V BEDINGFIELD with the words at the same time and place, and the sufficient contemporaneity rule of RATTEN V R with the words at different times and places. It may still be argued that the caveat that the possibility of concussion should be eliminated first before a statement can be admitted under Res Gastae isn't a relevant condition for the purpose of section 4, and therefore it is wider than the Res Gastae. So you see, there are three things under the common law rule. Number one, when you are talking about R versus BEDINGFIELD, talking about the strict contemporaneous rule, they are telling you that that particular thing that the person has said must be done at the same time with the act, right? Now, in R and Andrew and RATTEN V R, they said whether or not it was done at the same time with the act. What is important is that there was no time for the speaker to be able to concoct facts. Basically, what you are supposed to be looking at is the incidents that just happened. It must have dominated the mind of the speaker to the extent that it is very likely that whatever came out of the speaker's mouth is what can shed more light on what's actually going on, and it is less likely that whatever came out of the speaker's mouth is a concussion of fact. But when we are looking at the provisions of section 4, yes, it brought in the strict contemporaneous rule by telling us at the same time and at the same place. It also brought in the sufficient contemporaneous rule by telling us different time and different places. but there's something that he did not bring in, which is a very important factor, as stated by Lord Wilberforce in RATTEN V R. That is the fact that the judge must satisfy himself that there is no likelihood of concussion of facts. It is no longer a condition under our section 4 when we are admitting such evidence as part of Res Gastae. It is no longer a condition for you to be looking for whether or not there has been concussion or this. No, what is important is a statement made. Yes, the next thing that you need to ask, was it made in such a way that it formed parts of this same transaction? Yes. Can we say it is sufficiently contemporaneous, meaning that it happened although at different times and different places, but yet still form part of the same transaction? If the answer is yes, then we don't need to look at whether or not there has been a likelihood of concussion of facts, because at that point it becomes very irrelevant. Do you understand? So that's for the first question. Now let us go to our second question. Now, the second question, like I said earlier, we ask the question: a Nigerian court justify in admitting facts based on Res Gastae in total disregard of section 4? Both Aguda and Nwadialo, both who are Nigerian authors on this subject matter, suggest that the doctrine can be applied by virtue of section 5A of the old Act. But this view is erroneous. It was explained that this section allows for the inclusion or admission of evidence which is admissible under the common law but not provided under the Act. Section 5A of the old Act says, nothing shall prejudice admission of any evidence which would, apart from the provision of the Act, be admissible. So basically, they argue that the common law doctrine can be resorted to here where the Act is silent on particular matters, as can be seen in the Court of Appeal judgment of Onyawuni versus Ekpukpara. Now, the very important question that we need to ask is whether the Act has already provided for Res Gastae doctrine, and the answer is yes. Section 4 and Section 7 has already covered the field of Res Gastae, and it would be wrong to apply Res Gastae when the section applies. Assuming without considering that the Act is silent on the matter covered by Res Gastae, it is submitted still that Section 5A of the old Act can't be used to justify the application of the doctrine of Res Gastae. The only justification is for the court to expressly refer to the section either to admit or to reject evidence. Applying Section 5A of the Act in view of Section 7A of the old Act contradicts Section 2 of the Law Act, that is the Law Miscellaneous Provisions Act, which says that common law and equity are applicable except if other provision is made by federal enactment. There is no justification to apply Res Gastae when Section 7 exists. Nigerian courts have, however, been reaching decision based on Res Gastae rather than Section 7 of the old Act. So this is it. Under the old Act, note that there is no replica of Section 5. Section 5 under the old Act tells us that where there is no law on evidence on this particular subject matter, you can use the common law doctrine. Do you understand? Now, the argument of Aguda and Nwadialo is that there is no law on Res Gastae. However, we had Section 7 in the old Act. I think one of the reasons Aguda and Nwadialo made this proposition is because when you are talking about doctrine of Res Gastae under the common law, three things must be fulfilled. Number one, it must either be same time and same place, or different times and different places. So either strict contemporaneous or sufficient contemporaneous, and importantly, whether or not fact has been concocted. But the Nigerian Act only has two. So in their view, that cannot be Res Gastae. They are saying that Res Gastae will still be applicable as part of the common law doctrine, since the Evidence Act seems to be silent on it. But it is my submission that that is not true. Let us imagine that we are still under the old Act, meaning that you can still apply common law doctrines in our Nigerian court, which is no longer applicable under the 2011 Act. That's the Evidence Act 2011. Let us assume that the old Act is still applicable. Section 7 covers Res Gastae. The only thing is that it then in context of the Nigerian law, redefine our own doctrine of res gestae. We do not need to follow what the English law says, hook, line, sinker every time. What we need to understand, what was the essence of the Res Gastae doctrine when it was being applied in the English law? The fact that sometimes statements can be made when things are done. Those statements help us shed more light on those things that are done. As Section 7 in the old Act come to shed more light on those things that are done? Yes! But the only thing is that it removes a condition that Lord Wilberforce kept while he was deciding Rattin and R. So because that condition is removed, would Aguda and Nwadialo be justified to say that the Evidence Act does not have Res Gastae doctrine? I think not. And it is on this basis that I would say that their proposition doesn't seem to be the correct proposition. But do note, like I said earlier, it doesn't apply under the 2011 Evidence Act, because Section 5A, the provision has been taken away. What we have now is Section 4, and Section 4 is the Res Gastae doctrine. So in my next video, I'll be talking about the Nigerian cases decided under Section 7. After that, the subsequent video, I'll be talking about the Nigerian cases decided under Section 4 of the new Act. So this next video will be talking about the Section 7 of the old Act. Then the subsequent video will be talking about Section 4 of the new Act. I'll see you in my next lecture.